For the rest of these proceedings.
Carol Beaumont.
Mr Chair, I rise to speak to Clause 3 of the Employment Relations Secret Ballot for Strikes Amendment Bill, one of the worst pieces of legislation I've seen come into this House. Partly, it actually is bad because it's so completely unnecessary and probably the worst bill I've ever seen in terms of drafting. I was on the select committee that dealt with this bill, and of course when it came through it was so poorly drafted that what it meant was you had to have a ballot. It didn't matter what the conclusion of the ballot was, you just had to have a ballot. So you'd have a ballot and actually lose it and still you would comply. But anyway, going to principles of this Act...
Point of order, Jo, could you?
Mr Chair, I just seek your reassurance that we are talking about Clause 3, or am I mistaken?
Well, we are talking about Clause 3, and I indicated to a previous speaker to come back to line. The member in charge of the bill did some rebuttal, and that was acceptable. I've allowed some leeway, but I do ask that we are on Clause 3, and if we can focus on that from now on. Carol Beaumont.
Thank you very much, and entirely what I was going to do, as I said when I stood up, to the whip opposite. So let's talk about the Principal Act, shall we? Because Clause 3, of course, is the Principal Act amended. So I will make sure that I do a very thorough analysis of the Principal Act for the whip opposite. Now, of course, the Principal Act that is being amended is the Employment Relations Act, a very important piece of legislation because that legislation was a fundamental shift from what was one of the worst pieces of legislation this country has seen, which genuinely caused grief and trouble and led to a low-wage economy, and that, of course, was the Employment Contracts Act. Now, the Employment Relations Act that is the Principal Act, and the one that this bill seeks to amend, is a substantial Act of Parliament, the Employment Relations Act 2000, and the object of that Act, I thought I'd just talk a little bit about that and then link that to how this bill relates to those objects, I guess, and what the implications are of those objects for this bill. So the object of the Employment Relations Act is to build productive employment relations through the promotion of good faith in all aspects of the employment environment and of the employment relationship. And that is done by certain things, by recognising that employment relationships are built not only on the implied mutual obligations of trust and confidence, but also on the legislative requirement for good faith behaviour. Now, this is relevant to strikes, and so I'll link these two things together, but let me just finish by talking about the other objects of the Principal Act that we are amending. Secondly, by acknowledging and addressing the inherent inequality of power in employment relationships, something I don't think the other side of the House quite grasps, but there is actually an inherent power imbalance in employment relationships. Thirdly, the bill serves to promote collective bargaining, and the strike question is absolutely linked to collective bargaining, because the right to strike under the Employment Relations Act, of course, is really constrained to two main areas. One, around promoting collective bargaining, and when you are in the bargaining period, you do have the legal right to strike under New Zealand law. And the second main occasion that you have the legal right to strike in New Zealand is over a health and safety matter. Now, also, the object of the Act also includes protecting the integrity of individual choice. Now, this might be relevant, of course, and the members opposite might say, well, this is what this bill's about, so we'll come back to that as well. Promoting mediation as the primary method of problem solving and reducing the need for judicial intervention. Now, that's a very interesting one, and I will come back to that. And then, of course, the other main object is to promote observance in New Zealand of the principles underlying the International Labour Organisation Convention 87 on freedom of association and Convention 98 on the right to organise and bargain collectively. Now, as I've said, strikes are related to the question of bargaining collectively. So let's just look at what these objects mean in relationship to this bill, that this bill serves to amend the Principal Act, the Employment Relations Act. First of all, you would think that good faith, and in fact I know for a fact that these good faith relationships that are referred to in the object of this Act apply in multiple ways. So a union, for example, has a good faith relationship with its members. A union has a good faith relationship with the employer, and so on. An employer has a good faith relationship with employers' organisations. So it's kind of balanced, and so all parties have good faith obligations to each other. Now, the reason I point that out is that unions do have a good faith obligation to their members. So if a union was to force, which I don't believe is actually possible, and I've been a union organiser myself, but let's for argument's sake just say that a union can force, a union official we're talking about here, can force a member to take strike action. Mr Chair, let's say that that's possible. Well then, in fact, that member has the absolute right, under the Employment Relations Act, to say, my union is not acting in good faith towards me because they were forcing me to do something I did not want to do. They would actually have a legal remedy of breach of good faith. That exists already. Now, I think the other thing that I think is particularly interesting is this issue of reducing the need for judicial intervention. Because the Employment Relations Act is about relationships, quite deliberately, the wording of the bill was quite deliberate, it is about relationships. The idea was that the employment relationship would be one that was based on good faith and that you would try and deal with any problems at the lowest possible level. That was part of the underpinning basis of this legislation, which meant that you dealt with it ideally on the shop floor by having a conversation, and if you couldn't get it sorted that way, you might go into mediation or get some assistance like that, as opposed to getting into the legal situation. Now, under this bill, one of the real concerns that many of us have is that the bill that Tohanare is putting up here actually will give employers the right to take legal challenges against a union's strike ballot. So and often there has been some quite heavily contested collective bargaining situations in New Zealand's history where workers are well organised, they're in a union, they're trying to improve their lot, and unfortunately the employer is not coming to the party, they're not making progress, the workers decide to take strike action to put a bit of pressure on, because that's one of the two main reasons, as I said earlier, that you can legally take strike action in New Zealand. And so under this, they do their ballot. Well, actually, as my colleague and friend Darian Spenton has said, that would be the case anyway, because actually that's what unions already do. But so they take it under this legislation, they do their ballot. What this will do is give the employer the right to then intervene and have a legal argument about whether that ballot was conducted correctly. And we know, and this was actually drawn to the Select Committee's attention, so this isn't me making this up, this was drawn to the Select Committee's attention, that there are a number of quite significant cases overseas where that's precisely what has happened, that employers have used that sort of process to then intervene judicially, to go through a very long and costly legal challenge around the strike ballot to actually undermine the workers' ability to organise and collectively bargain. Now, that is one of the genuine worries that people have about this bill. And so you've got a bill here, the Employment Relations Secret Ballot for Strikes Amendment Bill, which is amending the Principal Act, the Employment Relations Act, but in my opinion is fundamentally at odds with the objects of the Act it's amending. Now, I don't know, I'm no expert on these things, but it seems pretty odd to amend an Act in a way that is completely counter to the objects of that Act. So just to reinforce that point, it actually explicitly says in Clause 3A6 of the Principal Act, the Employment Relations Act, that this object of the Act is to reduce the need for judicial intervention. And my contention here is that actually this bill potentially undermines that clause in the Employment Relations Act. And certainly it is unnecessary given the provisions in Clause 3A1 about employment relationships being on good faith and the requirement for a union to act in good faith to its members. So arguably, I think, and quite compellingly, there is a clear requirement on unions to have a democratic process by which to make a decision around taking strike action. And funnily enough, that's what they do. Anybody who actually is involved in employment relationships now and in employment relations now will know that in collective bargaining, when the issue of strike action comes up, there will be a secret ballot. So it's unnecessary. Now, I think it's very interesting that none of the people opposite, ACT, National, have actually thought about the other side of the equation, because as I said, the Act itself is quite balanced. It puts these requirements on unions and workers, but also on employers. And yet this Act fails to put any requirements on employers.
Tim McIntyre.